Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Friday, February 13th, 10:30 in the morning. We're just returning from the floor and we have our legislative counsel with us, Maria Royal. She is going to walk us through language on fictitious transaction activity bill that we were talking about. She drafted. This is the first time we have a chance to take a look at the language. I know working with bankers on this. So Maria, take it away.
Okay, great. Yes, Maria Royal with Legislative Counsel, and just share my screen. The document is posted. And as you can see, it's just a standalone document. It's being considered as a possible amendment to H 385 at the moment. And I'll just say that the original language came from the Vermont Bankers Association. It's a model that they had worked on. So we took that and revised it a little bit more. And we will walk through that now. So first is the findings and intent section. So this creates a new subchapter in Title 8. Chapter 200 is the chapter in Title 8 that has all of the kind of consumer protections, privacy that pertains to banking, financial institutions. So this is just another category of consumer protections in that chapter. So in terms of the findings, a covered entity, and that's defined essentially banks and credit unions. A covered entity has a duty imposed by law and contract to conduct customer-directed transactions in a timely manner and in accordance with the customer's instructions. 2, customers are increasingly being induced to authorize transactions that are not in their best interests. And then the intent section, the intent of the General Assembly to ensure customers have ready access to their funds and to provide a covered entity with the tools and protections to intervene in a customer-directed transaction when the covered entity reasonably believes the transaction presents potential significant risk of harm to the customer. And then a clarification, it is not the intent of the General Assembly to impose a duty on a covered entity to contravene the valid instructions of a customer, and nothing in this chapter creates such a duty. So trying to balance those competing interests. So as I mentioned, there are 2 definitions. So the first one is of account, and it basically lists all the different types of accounts. Banking customer might have assets, and then 2 associated third party. We'll go through this, but just so you know, it comes up in the context of if a bank feels it might be important to contact an associated third party who might have a relationship with the customer, if it seems appropriate, then the bank could potentially do that. But we'll look at the standards there. But just so you know who could be an associated third party for that purpose: a parent, spouse, adult child, sibling, or other family member of a customer whom a covered entity reasonably believes is closely associated with the customer. An individual the customer has authorized to be contacted by the customer's covered entity. A co-owner, additional authorized signatory or beneficiary on a customer's account, or an agent for the customer under a power of attorney, or D, a licensed attorney, trustee, conservator, guardian, or other fiduciary selected by a court or governmental agency to manage some or all of the financial affairs of the customer. So then the definition, as I mentioned, of covered entity: bank, trust company, or savings institution. And then that's just a cross-reference to the general definition of financial institution. So it covers all financial institutions in Vermont, all traditional banks essentially, or a credit union. And then it further goes on to specify that the term also includes the subsidiaries and affiliates that provide financial services for such entity, as well as the directors, officers, employees, or agents of such entity.
This wouldn't cover money transmitters, would it?
It's just the traditional banks, credit unions. The definition of customer for purposes of the subchapter means any person who establishes, maintains, or is a beneficiary of an account with a covered entity, including any person who owns, controls, or has a present or contingent legal or beneficial interest in funds held in the account, whether acting directly or through an agency, fiduciary, or representative. And then a definition of financial exploitation means A, the wrongful or unauthorized taking, withholding, appropriation, transfer, expenditure, or use of a customer's money, assets, or property, or any act or omission by a person, including by a fiduciary or other representative of the customer, whether acting under a power of attorney, guardianship, conservatorship, trust, or similar authority that, Roman numeral 1, line 15, obtains or attempts to obtain control over the customer's money, assets, or property through deception, intimidation, coercion, or undue influence for the purpose or effect of depriving the customer of the ownership, use, benefit, or possession of the customer's money, assets, or property, or converts or misuses the customer's money, assets, or property so as to deprive the customer of the ownership, use, benefit, or possession of the customer's money, assets, or property. So, and we get to section 10.803 on page 4, and this is the real substance of the bill, authorizing covered entities to take protective action. So subsection A, if a covered entity reasonably believes that a customer is or has been the victim of financial exploitation or attempted financial exploitation, and such belief is based on information either individually observed or received from a state, local, or law enforcement agency, the covered entity may take one or more of the following measures to protect a customer's account.
Yeah.
Yep.
I know this is really narrow, but just wondering if it would make sense that we also include any of the people that are the associated third party. Because right now it's really narrow on the bank, but what if those a child, sibling, or someone else calls the bank and said, this is what's going on, would that be?
I think that might be captured here. It might, so if a bank has a belief based on information either individually observed or received from an entity or, yeah, I mean, you could say, or a third party, or, you could expand that. So if they receive information
It too
from
far, because I don't want
anyone to be able to.
anyone calling and saying,
Yeah.
trying to put a hold on somebody, but. Michael,
That's actually, that's a really good point, because it, based on that reading, I can open that up.
So in terms of the actions, 1, delay or refuse one or more transactions with or involving the customer. 2, delay or refuse to permit the withdrawal or disbursement of funds contained in the customer's account. Prevent a change in ownership of the customer's account. 4, prevent a transfer of funds from the customer's account to an account owned wholly or partially by another person. 5, refuse to comply with instructions given to the covered entity by an agent or person acting for or with an agent under a power of attorney signed or purported to have been signed by the customer. Or 6, prevent or change the designation of the beneficiaries to receive any property benefit or contract rights for the customer. So those are all the possible actions that a covered entity could take. And then B, subsection B, further specifies that a covered entity is not required to take protective action under this section with regard to a customer's account, but may use its sole discretion to determine whether taking such action is warranted based on the information available to it at the time. And then subsection C, the authority to delay a transaction under this section expires at the earlier of 15 business days after the date on which the covered entity initiated the delay, when the covered entity is satisfied within its sole discretion that the transaction will not likely result in financial exploitation, or upon a court order directing the release of funds. So the earlier of any of those 3 events. And then subdivision 2 is allows for a continuation of time if needed. So unless otherwise directed by a court order, the covered entity may extend the duration of the delay for up to an additional 15 days based on a reasonable belief that the financial exploitation or attempted financial exploitation of the customer may continue. And then subsection D is, these are essentially protections for a covered entity to ensure that they are not breaching or violating their requirements for processing checks, depositing funds under the under the UCC Uniform Code, Commercial Code. Sorry, it's been a while. The UCC and under federal law, but we'll get to those in a moment. So again, just kind of specifying the authority of the bank, consistent with other state and federal law requirements. So any refusal, delay, or other protective action taken by a covered entity in good faith under this section to prevent the financial exploitation of a customer shall not constitute wrongful dishonor under section, and that's a particular section under the UCC. And I think that section has to do with, just so you know, bank liability for wrongful dishonor, so not depositing funds or releasing funds in a timely manner. Sorry, Herb, what did you say? Did you say that? Or was there something else? Did you just look that up?
I'm just trying, no, I'm not looking it up.
Okay.
I'm just trying to remember the chapter in the UCC, negotiable instruments, right?
Maybe. You know what, I'm very infrequently in the UCC, but there are numerous provisions that pertain to banking transactions, the processing and so forth. And as you know, the UCC is adopted in most states. So obviously banks do business across state lines. So there's some uniformity on how they interact with each other and with customers. And the same thing with respect to in subdivision 2, constitute reasonable grounds under the Federal Check Clearing for the 21st Century Act, the Expedited Funds Availability Act, and related regulations without imposing a duty to review every deposit or check individually. So in other words, if the bank does impose a delay and look more thoroughly, it doesn't mean that it has to do that in every single instance. So just, again, trying to be very specific about the parameters of the bank's obligations. And then 3, not constitute a violation of, again, a cite to the UCC regarding fund transfers between banks or related fund transfer laws, and any delayed payment order is deemed received only when the hold is removed and the covered entity submits the order for processing.
So the way that I see this process, somebody walks into the bank, they want to withdraw like $1,000 so that they can transfer it over to Bitcoin. To a kiosk. But the bank realizes, hey, this is kind of sketchy. They can hold that transaction for 15 days. And at that point, there's nothing that they're doing on their end because are they able to like file a police report or? Because I mean, holding it for 15 days is really great. But there's no, and I like the fact that we're indemnifying the bank, right? No
Yeah.
matter what happens.
Yes,
they're
if
not
they're following these procedures and acting in good faith. So in terms of what they might do, they might, if they can find an associated third party, somebody that they can check in with. That would, unless they can talk to the customer directly, otherwise they might reach out to somebody who could
responsible
verify or better understand.
regarding third party.
Yeah.
If they were to reach out to a third party, would they be crossing any privacy lines? And should we allow that exception? Because that would be, sorry, I'm losing my voice again. I'm just wondering if that could put them in danger.
Yeah.
Because that's private information.
Absolutely. No, I think that's a great point and really important to think through. And so let's read through the next section, and there are some parameters around that. But you're right, it's a tricky situation because you don't want to divulge private information. So with respect to notifications to associated third parties, a covered entity may notify an associated third party, if any, if it reasonably believes that the financial exploitation or attempted financial exploitation of a customer is or has occurred, and such disclosure is in the best interest of the customer. A covered entity may choose not to notify an associated third party if it reasonably believes that the third party is, was, or may be engaged in the financial exploitation or attempted financial exploitation of the customer. C, a covered entity shall limit disclosures to an associated third party to only information necessary to convey its suspicion that the customer was or may be the victim or intended victim of financial exploitation. And then finally, D, any disclosure by a covered entity pursuant to this section is exempt from the financial privacy protections in another subchapter of this chapter. And to the extent permitted by federal law under the Graham-Leach-Bliley Act, as those laws may be amended. So those are the state federal privacy protections. It's a policy choice about whether you think standards in here are sufficient to protect customers.
Just wondering if we shouldn't have some language in there that tells a financial institution when someone opens their account that this is disclosed to them when they open the account, so that it's known, the customer knows that it come in some kind of something that they want to do that looks suspicious, that the bank has the ability to do this. I don't know.
That's probably a great question for the bankers to answer. If I remember correctly, there was some conversation about designating a trusted person,
Right.
right? And there might have been some issues with that. So I think that's a great topic to maybe follow up on with them. And then the next section concerns just immunity for the bank, for the covered entities when they are carrying out protective actions authorized by this subchapter. A covered entity shall be protected from civil, criminal, and administrative liability for any act or omission within the scope of its duties and authorized by this subchapter, provided the act or omission is in good faith and does not amount to gross negligence or willful misconduct. And the construction is just how, it's basically, I think of these laws would be interpreted liberally, but because they're remedial and protective in nature, but this is just direction to the court or anybody interpreting the provisions. This subchapter shall be liberally construed to encourage covered entities to take reasonable protective actions to prevent the financial exploitation of their customers. Doesn't change the law, but to the extent there might be any ambiguity, the agencies that, and the courts would lean in favor of what is the most protective, consistent with the purpose of this chapter. So it's.
This is a requirement for all financial institutions that are named in there. But do we have the authority to do that with a federally chartered bank or credit union?
I believe so. I will check with the bankers, but I didn't hear otherwise. And the definition that refers to the definition of financial institution includes federally chartered banks, but I will confirm, make sure.
We have time, we can ask Chris weigh in on some of these questions. Any other questions for Maria? Maria, thank you.
Actually, Mike, I do have one if I may. Back at the bottom of page 4 in the part of the going on to the top, page 5, where it lists the actions. Is there any standards of documentation that the covered institution would need to meet? I'm sure some of it would be self-protection, but do we enumerate any of that in this act?
In other words, how they would document.
Yeah, the
Why, what
basis for making
happened,
the
and what, like a
decision
good
and what
faith
action they
basis, or-
took.
There's nothing required, so you could add that if you want to have a way of keeping track. I mean, that also might help the regulators understand how frequently this happens, so.
A good data point for us to understand how prevalent this is. Other questions? Great. Maria, thank you. If you'd like to join us now, or? Sure. Right, Chris, to the. Yes.
Morning.
Morning.
Morning. For the record, Chris Delia, Vermont Bankers Association, thank you for the opportunity to testify. First, want to thank Maria for the great work that she did in taking the language and putting it into a Vermont context, if you will. To Representative Cooper and to the folks over at DFR for working on this. So I think it's somewhat self-explanatory. It might be best just to try and answer your questions, that some that you've raised and maybe others. One of the key factors in this is that it's a may versus a shall. So it is discretionary based on the circumstances that are presenting themselves to us, which is important. The question about making folks aware of this, I'd like to explore what the opening of an account agreement looks like, and maybe it makes sense to put it in there. That may be an opportunity. The trusted third party is one that's, again, discretionary. because not all banks are there in their thinking about wanting to put in place a process for a trusted third party. That person is going to be identified for the bank. And the reason why some of the banks aren't all there is because what processes do you have in place to keep that updated, et cetera? But the information would only be shared with that trusted third party that's been identified and that the customer, if you will, signs off on. That one of the challenges with that is the trusted third party could be the perpetrator. So you got to kind of weigh those circumstances. The question of information sharing, Rabuten, on try and take your example. The way we envision this is you show up, you want to take $10,000 out of your account. That is, by current regulations, a suspicious activity. And we are required by federal law to file suspicious activity reports and create a paper trail, if you will, that is in our files and often goes to another agency because that is an unusual transaction. The 15 days is, in my words, nobody else's, a cooling off period. And it allows us to work with you, communicate with you, not in that moment, because in that moment, it could be a level of anxiety. You could also, as has happened, have a phone open in your pocket with people listening. So we want to kind of get away from that. And that's where the 15 days allows us to do it. It goes from the frontline teller to the branch manager to the security officer. And one of the things that we've got in Vermont, I'm sure it exists in other states, is a network of bank and credit union security officers with local, state, and federal law enforcement. So there have been many occasions where a bank will notify Secret Service or FBI. And sometimes that's done because it's a pattern of activity that they're seeing out there. But also, you get some situations where the customer is just not listening to you or doesn't want to listen to you. So you bring in that person who's got that, if you will, higher authority or title that, oh my God, Secret Service is talking to me. Maybe it is a scam. So that's how we envision the 15 days. And we think that can work really well. But ultimately, at the end, it's their money. And it's going to go back to them. So, or they've got an ability to do what they want. But I think this creates, in my mind, a very, very strong tool for our banks in Vermont. It is every bank. It is every credit union based on the definition. We would not want to segment out folks. And we're anxious to see how this can play out in the market because we understand in other states it's been a useful tool. How you decide to move it forward is up to you. We'll have conversations about that later on today, but we hope there is a path forward, standalone or otherwise, that this language can take. I'm happy to answer any other questions.
Is there any concern about a situation where a teller, maybe it falls through the cracks and they think it's legit, turns out it's not, and now that teller is on the hook because he allowed a fraudulent transaction to go through? Is there any concerns around that?
I mean, we would have those concerns today because and that's why it is incumbent upon us, and what our banks do on a routine basis is the training of our frontline workers to ensure that they know, one, what the internal processes are, but two, what's the evolution in the market related to fraud and scams. So is it possible something falls through the cracks? Yeah. And that would be a legitimate reason why a customer could come back and raise an issue with the institution. But we try and minimize as much as possible with the training and updating of information that we provide to our frontline folks.
What about the question I asked earlier about documenting these things. Is there
Right, so,
recommended minimum amount of information you would want to see? I would
Yep.
think it would be, excuse me, but protective of your institution
right.
as much as anything else.
so in my mind, the documentation is already occurring because we have certain regulations through our federal regs and requirements that say we have to either create the suspicious activity reports. There are currency transaction reports that we have to do, notice unusual activity. All of those reports are kept in the files, and then when the examiners come in, they will look at those reports. So it isn't that we're creating that documentation, and it is available to our bank regulators. Could they take that and from it? What's been happening out there or the impact of this? Yes. Over time, they could.
So. Yeah, I think I'd like to see the data after the effect of, how many people were saved from fraudulent activity. And would we be able to gather that information from the reports that are being generated now?
Excuse me. Currency transaction reports, yes. Suspicious activity reports goes into a giant black hole that we never see, quite candidly, because it's with the Financial Crimes Enforcement Network. You're also going to run in, well, are you running into this? Trying to think of how you compel a nationally chartered bank to provide information. State charters, sure. I would not have a problem with language in there that would require us as an association to come back to you within some defined period of time. I think we got to let it mature and report back to you. And then my goal would be, we'll go survey all of our members and we will provide you that data in an aggregate format so that you have a sense of whether this is really working or not, or if we need to tweak it or do whatever. I don't have a problem accepting that responsibility.
That's reasonable.
I was looking through the report from the committee that worked on this over the summer.
Yes.
There were two things in there that I want to make sure are in here, and I want to make sure work with you. One of them was notifying DFR when this happens, and then they would be the repository of all the information, and it would take a load off your association. And it would include anybody who isn't in your association to get that information. So that might be a little bit broader. So I don't know if that. So notifying them, I don't know how much, I don't want to create more paperwork, but I also want to ensure that we're including, being inclusive of all the data, all of the information that's happening across the state. So I want, if you could noodle on that for a little bit. Because that was in their report that they would prefer, they would recommend that they are notified. And the other thing was that this, it's only a hold on this amount of money, but that the customer still has.
Correct.
And I want to make sure that, and that might be a Maria question, but that's written in there very clearly, that it's.
Yeah, if it's not, absolutely, it should be clear. We have no interest in holding up your account for anything but what is perceived to be suspicious.
And I think that's part of the notification to the customer. This is.
Yeah. Yeah, I'll also see what, for the other states who have enacted this, how their banks have conveyed it to the consumer, but I'll look at that, but I'm thinking that the account opening documents, that's a natural area to look at that.
And I think we have the authority.
Right. Right. Yeah, just develop a
Or
paragraph.
we have the authority.
Yep.
We have a recent experience in my family where it was, we thought it was understood that money was being transferred to make a purchase in a car stopped working.
Mhm.
My story in car problems. But, but it ended up being a bank check that took more time, right? That was being made, it was one of those things. And so then a money order was being written in that same amount from the same lending. So it could have felt like it was a suspicious transaction. And I'm curious in that, two large amounts of money to the same place. One didn't get there, but it should, but there was a real time limited
Yep.
issue. And I want to make sure that that's not going to get swept up. And this is like one of those weird things that
Yep.
I want to make laws around those weird things and right, like, so is that the kind of thing that in training would be?
Yeah, well, I think that's the type of thing that, yes, in training, but more importantly, is part of the conversation with you as you're standing there doing the transaction. People go in and get bank checks all the time. I did it the other day for my wife for laser surgery and took money out in a bank check in her name so she could deposit it in her account and then get the surgery. So it happens all the time. And that's where I'm envisioning, because we're going to obviously have to do training just on this alone and make folks aware of the new tools. So I think that's part of the conversations with you as a customer.
To that point, I think as we were describing to Edie's comments about like, are we clear enough when, in line 20 on page 5, we're saying without imposing a duty to review every deposit or check individually. I wasn't sure there's any other time that we're being clear about it being just one thing and not every bit of activity in the account. Is that elsewhere? Is that?
I'm fine if we work with Ledge Counsel to make sure it is absolutely clear that it's only that transaction that we're talking about. I don't want to impair the rest of the account. Well, we don't want, I should say, we don't. The rest.
Any other questions from Chris? Okay, great.
Thank you.
Thanks, Chris. Thank you for your work on them.
Thank you.
Thank you, Maria, as well. So fix those areas and back to it. So I think there's no other questions for Maria or Chris. We're on at 11:30 with our next presenters. So why don't we take a 20-minute break, be back here promptly at 11:30. So we can hear from our